A whole bunch of states' attorneys general telling the U.S. Supreme Court they have to intervene in the case challenging Illinois' gun and magazine ban to make it clear what the Second Amendment is all about. Welcome back, Bishop on Air. Like, subscribe, hit that notification bell, and let's get on into it with a review of the docket for the U.S. Supreme Court in the case Barnett v. Raoul. That's the challenge of the state's gun and magazine ban. But before we look at the U.S. Supreme Court's docket there, let's take a look at where we're at in the Southern District, because I think it's important that we have background on where these things are, right? So we're getting ready to talk about not just the state's attorneys general, but also others who have filed to the U.S. Supreme Court saying that they should intervene in this case challenging the state's gun and magazine bans in the U.S. Supreme Court. But the case is still going on in the Southern District of Illinois. So way back, January of 2023, right, the state enacts a ban on certain semi-automatic firearms, a registry component that goes along with that, and a variety of other prohibitions on attachments and magazines over certain capacities. That was January 10th of 2023. About a week and a half or so afterwards, you had the first case filed, and that was from Thomas Magg in the case Langley versus Illinois. And that was filed in state court. But then it was quickly transferred to the Southern District Federal Court. And then you had other lawsuits filed in federal court against the gun and magazine ban from different groups. While that was going on, you had the Beavis case in Naperville challenging not just Naperville's ban, but they amended their complaint to challenge the state's ban after it was enacted in January 2023. So you had another case out of Chicago and several others. I believe Highland Park had some cases as well. So you have this mix of cases in the Northern and Southern District. In the Southern District, you had this plaintiffs group. 4 of them were consolidated by Judge Stephen McGlynn. And on a preliminary motion for an injunction, which is kind of a first step before you get to a permanent action against the law, you have to, lawyers can say, hey, we want to immediately halt this law while the case proceeds because it's harming people. Judge McGlynn, he granted that preliminary injunction. And if you recall, you had 6 days where that injunction was in place prohibiting the state from enforcing the law. And that was like, late May or late April, early May, whenever that was happening in 2023. And then you had the Seventh Circuit Court of Appeals grab the case and essentially tell McGlynn that his order blocking enforcement is on hold while the case proceeds. And then the Seventh Circuit took the case. And there were requests for the U.S. Supreme Court to intervene at that time. But the U.S. Supreme Court said, no, let the Seventh Circuit deal with it. The Seventh Circuit heard the case, and then 4 months later, they issued their ruling. And their ruling essentially was, hey, on a preliminary basis, the state looks like they could be the victors in this. But they kicked it back down to the lower courts in the Southern District to deal with the merits. And that's where the Barnett case, that's the case that wraps in the Langley case, the Barnett case. You've got a State Rifle Association case in Harrell and the Federal Firearms Licensees of Illinois. So you've got these cases that are all lumped together in the Southern District, going up to the appeals courts, now back to the Southern District. But at the same time, these plaintiffs groups have asked the U.S. Supreme Court again to intervene. And that's kind of where we're at right now. So back in the Southern District, we're still waiting on the latest from Judge McGlynn in this case, Barnett v. Raoul, where you have filings that are happening, including filings, about expert witnesses. And some of the timeline that Judge McGlynn has laid out here includes, March 27th, which is yesterday. The attorneys are to be sharing around various experts that they hope to use. Then we're going to see here in just a handful of days respond to request by writing. The discovery with which the court should be carbon copied no later than April 3rd. So these are some of the next days here that we're going to see some things happen. Just a side note, apparently the state is no longer having one of their attorneys represent them. Attorney Hal Dworkin is terminated, they said last week in a filing. So interesting to see that. So that's in the Southern District. That case is still going on because you have Judge McGlynn saying the Seventh Circuit's order has been issued. It's down back into the Southern District. We're going to deal with this on the merits. And you had even the plaintiffs and the defense saying, well, hold on, you got the U.S. Supreme Court. What could happen there? McGlynn said he doesn't care. He's moving forward with this case on the merits to build a record to then take it up. But you've got the preliminary issues that plaintiffs are asking for the U.S. Supreme Court to intervene. So while the case in the Southern District continues, you have the docket for the Barnett case in front of the U.S. Supreme Court starting to stack up here. So if you see on February 12th, the plaintiffs filed for writ. Then you had some other filings back and forth. But then you get earlier this month, the Illinois Sheriff's Association, they have filed for an amicus brief to essentially side with the plaintiffs on this. So let's go ahead and take a look at that particular document from the Illinois Sheriff's Association. Where you've got questions being raised on a variety of things. So click through, and you can find all this by going to the U.S. Supreme Court's website and searching Barnett, and you'll be able to find all of these pleadings. But just looking at the table of contents can really give you a good idea of what's going on here. They talk about the Seventh Circuit's decision and how it can't be squared with the U.S. Supreme Court's precedent. The majority's refusal to recognize that the firearm and ammunition feeding devices banned by the state law are arms demonstrated its determination to undermine the court's holdings. The majority's reliance on dissimilar historical regulation undermines this court's holdings. This court's immediate interventions required to avoid compelled enforcement of regulations that are facially unconstitutional, the sheriffs say. So that's just the outline of what the sheriffs have to say in their filing with the U.S. Supreme Court in order for the U.S. Supreme Court to actually take that. But you also have a brief filed by Idaho and a whole bunch of other states. And this one's interesting as well. This came earlier this month as well, where you've got Indiana, Alabama, Alaska, Arkansas, Florida, Georgia, Iowa, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Utah, Virginia, West Virginia, Wyoming, and the Arizona and Wisconsin legislatures in an amicus brief. So you've got these state legislators essentially saying, hey, you need to intervene in this. So the questions whether Illinois' sweeping ban on common and long lawful arms violates the Second Amendment. Then you look further at their table of contents and their arguments. The Second Amendment and the U.S. Supreme Court's decision supply a clear, principled method for determining what conduct's protected. The Seventh Circuit's pronouncements, the arms owned by millions of law-abiding Americans are not arms, defies logic. They go on to say the firearms at issue are arms under the Second Amendment's plain text. The Seventh Circuit's conclusion that militaristic weapons are not protected is wrong and illogical, they said. The Seventh Circuit's historical examples do not justify Illinois' total ban on common arms. So they say that the court's intervention is needed now. So again, that's various general assemblies and state legislatures from all of these different states, right? I mean, Indiana, Florida, Texas, Utah, Arizona, Wisconsin, all of these different legislatures filing an amicus brief saying that the Seventh Circuit U.S. Court of Appeals is wrong in their decision against the state's plaintiffs seeking to have the gun and magazine ban reversed. So that's just one of the pleadings. And then you had another one from the Buckeye Institute filed, and also another from the American Firearms Association. So the briefs continue to stack up in the challenge, now being requested for the U.S. Supreme Court to intervene. So fascinating to see all of that. But again, while that happens, you've got the Southern District of Illinois continuing on the merits. Because there's the difference between, and I'm not an attorney, I'm just a reporter who's been tracking this rather closely. There's a difference between addressing something on the merits, getting to the heart of the matter, versus preliminary steps, initial steps to say, we need action now to halt this while we deal with the heart of the issue. So I believe what the U.S. Supreme Court is looking at is whether or not they should intervene in that initial request for preliminary action based off of the Seventh Circuit's U.S. Court of Appeals 3-judge panel that essentially two of those judges, the majority, said that, well, these arms are kind of militaristic, and there's a difference between civilian arms and military arms. But the plaintiff saying, in all of these amicus briefs, saying that defies logic from what the U.S. Supreme Court has previously said in Heller and in the New York State Rifle Association versus Bruin. So that's where we're at in the grand scheme of the gun and magazine ban in the state of Illinois. We'll be tracking it, of course, but that's not the only case that you've got. You've got cases dealing with public transportation and whether people can carry firearms there. You've got cases about the FOID card, which is going to be interesting to see how those continue to move forward, and so much more. So be sure to like, subscribe, hit that notification bell, and we'll update you as stuff comes in when we see it, all right? Appreciate you guys. And email me anytime as well. Just email bishoponair@gmail.com, all right? bishoponair@gmail.com.